I am positive I will mispronounce the next case name, but I'm going to do my very best. Cambaz Negaban versus Shabnan Negaban. I'm sure you will correct me. 24P1226. The case is partially impounded. So, counsel, I just remind you of that as you make your presentations. I assume it's impounded on the financial statements question.
Thank you, Your Honor.
Just let's give Mr. DeFerias a moment to clean. Take your time, sir. Thank you. Mr. Attorney, good morning, or afternoon now.
Good afternoon, Your Honor. Justices. Just to correct one thing, I believe, and I just found this out half hour ago, the judgment and the findings in this case are also impounded for some reason. There was a joint motion filed at the trial court level that was allowed, so I'll try to be careful in walking around references to that.
All right, well, why don't we refer to the parties as husband and wife?
That's fine. Judge, this is an appeal from a divorce judgment entered by Judge McSweeney after 9 days of trial in the Middlesex Probate and Family Court. My client, the husband, is a practicing ophthalmologist. He runs a sole practice down in Easton, Massachusetts. He has nobody else working for him, no other doctors working for him. And that was one of the issues in this case, was the valuation of his interest in EEC. That's what it's referred to as, Easton.
So you have two issues. One is that you claim a double dip, and the second is, where did the trial judge get this value from?
Those are two issues.
As it relates to the practice.
Correct.
So let's talk about the value of the practice for a minute. As I understand it, your expert, you were not trial counsel, right?
I was not, Your Honor.
So the husband's expert essentially said there was no value. It's goodwill only. Is that right?
Correct.
I'm not surprised that didn't go anywhere. So tell me, as you understand it, we had a value from wife's expert, and I'm probably going to ask Mr. Heenahan this. Are you suggesting that you can't extrapolate from that testimony the value that ultimately Judge McSweeney found?
I don't think you can, because what he did is Judge McSweeney said that I'm adopting essentially the methodology used by the wife's expert in this case.
Didn't he have an issue with the cap rate?
He had an issue with the cap rate, and he had some other adjustments that were made. The initial report filed by the wife's expert came in at about $2.2 million. At trial, it was reduced to $1.3 million, and Judge McSweeney, after findings...
$996 and change.
Correct.
Okay.
How he went from the $1.3 million down to the $990...
I have $1,000,001. I have $1,158,970. That's at page 24 of your brief.
Yes, you're correct, Your Honor. Okay. So he dropped it by a couple $100,000 or close there, too.
You don't think that the finding on the cap rate would account for that?
I don't think so, Your Honor. And the other issue is there's no explanation in the findings. So when they come up to this court for review, it puts us all in a precarious position because we don't know what it is the judge actually did and why he did it, so that you can adjudicate whether or not he was erroneous in doing what he did. But I think the other issue that's important in this case, dealing with the double dip, is the fact that this was a sub-S corporation. My client is the sole owner, 100% stockholder. The income that came to him over and above the salary that he took out was reported on his tax returns through a K-1 form, as subchapter S corporations do. And when you look at the analysis that put aside the husband's expert that said it's not worth anything, when you look at the analysis done by the wife's counsel, what he did was that he essentially took about $170,000 worth of profit the company generated each year, and that's the profit over and above the salary taken out by the husband, over and above the expenses, the adjustments that were made. And he capitalized that $170,000 of profit. When you capitalize that, even using a 15% rate or a 13% rate, that comes out to about $1 million, which would wipe out any value that the wife's expert even attributed to it.
So for business flow purposes, What happened to that excess profit? Did it go in your client's pocket?
It did, and it was then used
Reinvested into the practice.
I'm sorry?
Was it reinvested into the practice, or did the family use it?
Mostly the family used it. They ran a very tight line on how they lived. They lived well beyond their means, the court found, and I think based on the facts, they had no retirement. They had 4 children, no savings for college for any of them.
So in the wife's expert's testimony, did the expert back out both the salary and the profits to normalize earnings and reduce it so that we're avoiding a double dip?
He used the profit to value the business. And
I
then...
understand, but I'm trying to follow potentially how Judge McSweeney got to his number. So, did the expert testify? Did the expert back out both the income that your client received as well as that profit number? And then value, or no? I
think he addressed the salary that my client was taking, because my client took my income by salary and then took out the K1 profit, not always the exact same amount that the K1 said, but he took money out of it, and that was utilized to support the family. But the problem is that then what the judge did was he utilized that K1 profit in calculating my client's income. He had salary and he had K1 profit. I think that was finding 46. And then calculated based on that what his support should be. And you can't, I think it's the ultimate definition of what a double dip is. You can't use the profit to value the asset and then use that same profit to utilize it for setting support. And I think that's really the big issue here. And as I said, we don't know what it is or why it is that the trial judge did what he did, other than to say, I have a problem with this 2%, that he didn't adjust some earlier years of income of the husband in this case.
So if you look at findings 80 and 81 of Judge McSweeney's decision, which is at your brief at page 75, he explains why he doesn't credit husband's expert. But if we could look at 81, he explains, you might not agree with it, but he explains his adjustment in finding 81.
Well, he explains that this 2.6% adjustment that the wife's expert didn't make to earlier years of income, because this was, keep in mind, this case was valued, the business, as of December 31st of 2020, and that was a whole other issue because that was the first COVID year.
I'm not going to ask you to concede anything, but hypothetically, if you didn't have the double dip argument, if he didn't base support based on your analysis, would the valuation stand?
I think if you took that income out of his income for purposes of setting support, and it's in the valuation, then that's an acceptable methodology. But you can't do it twice, and you can't do it in both circumstances. And as best I can calculate, and I'm not an expert I'm not an accountant or a business valuator, but I've seen enough of it over the last years that I've been practicing. When you capitalize that $170,000 profit, that's the goodwill or the money earned over and above what was taken out by salary, that wipes out the value that the wife's expert found in this case. And we can all divide $170,000 by 15%. That's $1.133 or $1.33 million, which is more than the value even found by Judge McSweeney as adjusted. As I've said in my brief, when we look at the income that was had here, there was...
When you look at the value of the business, do you agree that the value... He bought the business, right? He bought a client base.
He did.
Right. And he paid money for that, right?
He did.
And so why would you suddenly assume there's no value to that client base?
Well, I think, first of all, the business was purchased many, many, many years ago before the trial, number one. Number two, we now
have... Right, but the idea is you're building... You're not walking in with no clients. You're walking in with a potential stable of clients who can choose to leave because they don't like the new doctor, or they can choose to stay. right?
You'd like to think that, and I think what was testified to at trial, the evidence was that the first doctor that he bought the practice from stayed around for a little while to help transition with clients and things like that. But when you looked at it at the time of trial, as of December 31st of 2020, it was the valuation date, you had a sole practitioner that was, if he's not showing up on Tuesday, all of his Tuesday patients get canceled. If he breaks his leg and is out for 3 weeks in July, there's 3 weeks worth of patients that aren't being seen. He doesn't have an associate that he can send them to. So I think that was the basis. I'm not here appealing the fact that my expert his value wasn't adopted. I'm not saying that because I know it seems drastic to say in a business that it's worth nothing. But when that business is also generating an income for the owner, and that total income, the profit as well as the salary, is then being used to set a support order, I say it was in fact, included. And I think in these circumstances it would be appropriate, although that's not an issue on appeal. In terms of the other issue, because as I said, the other assets in the case, there was a house in Newton. There was a condo that my client had owned prior to marrying his wife. There was an interest that he had in his family condo out in California. A lot of the trial, as you'll see, and I apologize for the length of the appendix in this case. It's not what I typically would do, but you'll see there was a lot of time spent about alleged assets in Iran that weren't disclosed, and all that was found to not be non-supported, the wife's claims on those things. But what happens is you've got this valuation on the business, then you've got the issue of the house, which is the third issue that I'd like to address. They bought this house.
Before you get to that, the wife cites a case Adlaka versus Alaka from this court. I just wondered what you had to say about that case.
I'm sorry, which case?
Adlaka.
I don't know that that's directly applicable to this particular case, quite candidly. First of all, I think it was a Rule 128 or Rule 23 decision.
It's published.
No, it's published.
Oh, it's published. It's fully. My apologies. But I think in this particular case, it was unique in that it was a small, essentially solo practice that was being valued here. And there are differences between the types of businesses that the probate and family court deals with all the time. Big businesses, small businesses, sole practices, limited liability corporations, etc. But in this particular case, I think when you look at what it was the judge did and how he valued this business, that's where the error is.
So did your client argue to the judge, hey, be careful, you can't double dip here?
Did he say that?
Did he flag this issue before the...
I don't think anybody really knows whether there's going to be a double dip until the probate court judgment comes out. Until there's a decision saying and explaining, I think, to the extent you need it reviewed, that he did utilize this profit of the business in both the valuation and in the support. You don't know that that's going to necessarily happen until after the fact. There were post-judgment motions filed in this case and to try to correct it in that respect, but I don't believe in my reading of the transcripts that specifically was addressed early on. In terms of the house purchase, that, again, we say basically ignores on its face an $830,000 liability, and in reality, a liability that with accrued interest was about $1.3 million. We say that was clearly erroneous. The facts here were uncontroverted. They were uncontested. The fact that my client bought this house, that the year before he bought the house, he was earning, I think, about $27,000 or $29,000. There's no way he would have qualified for a mortgage for this $2+ million house he bought. There's no question that the money, $830,000 of it, came from his mother. There was evidence shown for transfers from a Deutsche Bank, his mother's account, into...
The bad news is that the judge didn't believe it, and aren't we bound by his credibility determinations?
Well, under a clearly erroneous standard, I think I have that problem. But here, the judge said, I I don't believe it, and here's why I don't believe it. A, the mortgage on the property wasn't recorded until almost 10 years after the promissory note was signed, and that was explained by my client. Wasn't contradicted by the wife, that after 10 years, his mother was growing concerned about the investment she had made. He found out, and she found out about her.
Judge didn't have to believe that, did she?
Judge does he have to believe it? No, but there was nothing to contradict it. There was no black and white stories being told here. The only evidence was that the husband borrowed the money.
The evidence was there was starting to be trouble in the marriage and his family circling the wagons, which happens.
It does happen. It happens all the time. But there was no question that the money that came in based on the HUD closing statement, based upon the documents that were introduced as exhibits in the case, from the closing lawyer's file, the monies that came in from the Deutsche Bank account of the mother, that this $830,000 came
But nobody's
from mom.
saying that the money didn't come from the family. The judge determines that he does not find the promissory note credible, which is another way of saying, I don't think it was a loan. And furthermore, I don't think it was a loan that was secured by a mortgage on this house when the mortgage was entered a decade later at a time that's quite helpful to your client.
I understand, Your Honor, but what I'm saying is there was nothing at the trial, this 9 days of trial, that justified him making that finding.
Well, your client testified, right?
My client testified he borrowed the money from his mother. It came in via wire transfer. I signed the promissory note. The judge found that because the promissory note wasn't notarized, that somehow shed some question on it. There's no requirement under Massachusetts law that a promissory note be signed. The judge found that because my client hadn't made any payments on the note for some 10 years, that somehow justified it as not credible. When you read the note, the payment isn't even due with accrued interest until 30 days after the house sells. So there wasn't even any requirement.
Is the house on the market now?
Hell, it is. That's a whole other issue, and there's another case up here that's not yet been briefed. It'll be briefed next week. It's case number 25P1118 about some contempt matters, and you'll see I think I have a motion to file a supplemental record appendix on something that transpired after the divorce judgment, where my client was brought in on a contempt for not selling the house, and he was found not to be in contempt because the judge recognized that he can't impact the rights of the mother and the sister on that basis.
Counsel, your time has expired, but just so I can check with my clerk's office, you said that you just learned that the judgment is impounded, and what else?
And the findings of fact and conclusions of law.
I'll check with my clerk's office, and we'll make any adjustment consistent with the rules.
Okay.
Thank you.
Thank you very much, Your Honors.
Mr. Heenan.
Thank you. Madam Chief Justice and the Associated Justice, I'm Brian Heenan. I'm from Cates and Paolo. I'm here on behalf of Showdown Negaban, and we're asking that the judgment of the court be upheld and all of the issues being contested.
How did McSweeney get to that value?
Before I answer that, can I just mention one thing?
Sure.
Okay. So there was, in addition to the thing that Attorney Cherney just mentioned, there's also another proceeding that resulted in a judgment related to the house issue that's dated June 13th, 2025, and it was included in this record appendix at volume 12. Attorney McSweeney, as he indicated...
Judge McSweeney.
Judge McSweeney, yes. Judge McSweeney, as he has indicated...
Although he's retired now, so he may be Attorney McSweeney again.
Maybe at some point in time, right. So, as he indicated in the findings, he largely concurred with Mr. Tolman's findings.
It just had to do with the cap rate.
Well, there were a couple things that he changed, okay? Number one, as finding 81 says, Mr. Tolman did not normalize husband's income for 2016 and 2017. Mr. Tolman had an explanation for why he didn't do that for 2020, which the judge accepted. Mr. Tolman did adjust the amount for 2018 and 2019. So although Judge McSweeney largely concurred with Mr. Tolman's expert testimony, he made two changes. One, he adjusted the income for 2016-2017. Two, he made a change to the capitalization rate. Mr. Tolman reduced his capitalization rate to 2.6%, and the earnings weren't showing that rate, so the judge made...
So the average EBITDA would have gone up, and the cap rate would have gone down, right?
Yes.
Okay.
Okay, so he made an adjustment.
That math come out to the 996 number? I haven't done the math.
I haven't run the math myself, and without the cap rate change, it's hard to know for sure. But I can say that the adjustment he made, the value that he wound up with, is 85% approximately of what Mr. Tolman testified was the rate, in which he largely concurred with. And I would add to that
the value is 85% of wife's expert's number.
Correct.
Okay.
So I would say that with response to some of the things in the appellant's brief, that this is not an important thing. It's not like failing to value a business or failing to acknowledge a mortgage. This is a pretty minor percentage thing. And keep in mind that...
Well, it's a big deal when his expert said the value was zero.
Well, that's exactly right. And that's the problem that he created himself. Dr. Negabon put a witness on the stand who testified that the value of his company was zero when he had $25,000 in a PPP loan that had been forgiven, $105,000 in his bank account, another account with $100,000, and equipment with a book value of $130,000. But he had an expert witness testify.
What's that? That's roughly between 4 and 5?
It's getting close to $450,000, Your Honor. And so, and Dr. Negabon testified under oath, again, that it had no value.
So let's call it 450 in fixed assets, and basically another, I'm rounding, another 500,000 based on his capitalized earnings.
That's one way to look at it. But in any case, the standard of review, which wasn't discussed earlier, was any reasonable view of the evidence and inferences reasonably drawn from the evidence. And there's nothing unreasonable about what he did. He did explain what he did. There is one calculation that...
Then to double dip. Why is it not a double dip?
Well, it's not a double dip for some of the reasons we've discussed already. One of it is that he deducted... Tolman deducted the husband's salary from EEC's overall value. Okay? There's a lot of reference in the brief of the appellant of excess...
What about the 170?
I'm sorry?
What about the 170 of excess profits? Is that factored into the valuation and for purposes of support?
Well, I don't think so, Your Honor, because keep in mind the support was $75,000 for a family of 5. And they did not appeal the issue of support, and I think that's why. I don't think there's any way you can say that all of that income was considered for support and wind up with a number at that level. Now, the other thing I wanted to mention, as whether or not there's a double dip, is a double dip is not strictly prohibited, although I don't think there's a double dip here. There's issues of equity, and issues of equity include, in this case, a family of 4 and my client who has no history of earnings with almost no bank accounts and no retirement assets and no money set aside for school. So the only thing that she has to rely on is the amount of money she gets in support, some money from the Cambridge condo.
Okay, but you didn't cross-appeal on the amount of the support, and now you're saying the support is so low that helps us think there was no double dip?
Yes.
Okay.
And one of the reasons, not to get into it, but one of the reasons to not do that, because on balance, we thought the judgment was fair. And so we weren't going to go and try and pick one thing about it we thought was unfair and fight that. Now, with respect to the value assigned, the court found, as we talked about, $1.158 million and change as of December 2020. And that value was somewhat depressed, of course, because of the COVID situation at the time, which affected the earnings at that period of time. Both of the experts used the capitalization of earnings method. And the case is distinguishable from Reading. One of the arguments made is that, there's two separate streams coming in. One is the salary which was deducted. The other is the profits. And similar to the case that was asked about earlier, it's a similar situation. The only difference was that that business owner was a sole proprietor, and he is a sub-S corporation. Both are reported on the tax returns the same way.
So, but I'm still back to Chief Blake's question, which is, were the profits taken out for purposes of valuing the business?
No, the salary was taken out for the purpose of valuing the business.
But then were the profits not taken out, was the profit used for the support? And I guess you're saying it no.
Not based on $75,000 of a family for five.
But historically, did the judge make a finding about what the excess profits were used for? Attorney Cherney suggests that it was used to help support the family because clearly they were living well above their means. And that seems like that would ring true to me. Is there a finding about the excess profits?
I don't believe there is a finding about the excess profits, and I push back on that term. Profits aren't excess. Profits are the goal of a business, and they were used
in conjunction with his salary.
Okay, well,
in addition to his salary.
Absolutely, it's in addition to his salary, and absolutely those funds were used, except the couple $100,000 I mentioned in the bank accounts. Those funds were used to support himself, his wife, and his family, and both prior and post separation. One other thing I'd like to mention in terms of that, though, is in terms of the attorney's fees. Despite his income and supposedly having no income from other sources, Dr. Negaban paid all of his attorney's fees in advance, $426,000, which was more than he owed at the last day of trial. My client was unable to get an advance of fees and wound up owing $237,000 in change.
Got a pendente lite order at some point in the case.
$30,000. The total amount she received during the litigation was either $65,000 or $85,000.
So I'm sorry, how is that he gave all this money, paid all this money to his attorneys? What is that relevant to for us?
Well, one of the questions is how did this family live beyond its means? And although the judge found that there was no monies in Iran, the judge did find that the second mortgage was illegitimate, despite all the evidence that Attorney Cherney mentioned in his argument that suggested perhaps it was legitimate. There's a whole series of findings.
But that's not an issue that's before us. I mean, the issues that are before us are the legitimacy of the calculation of the valuation of the business, whether there was double dipping or not. Mm-hmm. And then this other question that I don't think you've addressed, I don't know if you want to, about the judge's ruling on the purported third-party mortgage.
Right, I do. And in fact, during the original discussion, the paragraph of the findings that was, I think it was 85,
Right, it's on page 130 of volume 6 of the record appendix. Paragraph 20.
Yeah, I'm looking at 21. Okay. No, that's not what I'm looking for, sorry. So the court found that the second mortgage was illegitimate. One of the reasons the court found that way is because it wasn't recorded. Another reason that it was not credible was because the mother submitted a bond affidavit that didn't mention this debt. The father refinanced the mortgage in 2013 and didn't list that promissory note as a debt. As mentioned, he didn't make any payments on it for over a decade. If you look at it, that this was created as a fiction, basically a family fraud, and you say, okay, well, what happened? A month before the divorce, they write up a note. Why is it not notarized? Because you can't get a past date on a notarized document. Why is it not signed by everybody? Because there's no time to do that.
So I apologize if I missed this in the record. It is a big record. At some point, did you seek to bring the mother in as a third party, and was that denied?
Yes. It was the representation made to Attorney Doniger, the special master, was that she was too ill to be deposed even via Zoom.
Did you try to interplead her in an equity complaint as a defendant?
I did not.
Okay.
And the sister was also not called as a witness. Now, the mortgage, the promissory note lists $830,000 and two obligees, but doesn't list who's owed what. And there was some testimony about that. It's in my brief that lists the various amounts and how they don't necessarily add up. When the court issued the order for him to take the steps necessary to initiate the steps necessary to get rid of the mortgage, he filed an appeal on this. It went, like I mentioned, it went back to the court. There's a second judgment, which he's supposed to now, with it 14 days before the sale of the property, he's obligated to either have it dissolved or pay it. And that's also on appeal now. Neither of those judgments has been stayed. The house is on the market, and that's
I saw that there was a mod filed after this case, and did someone I don't know whose mod it is, did someone get permission from the single justice to file a mod?
The filer filed the mod. I raised the issue of permission. They said it was not required. Right. And it was I raised the issue. He filed a mod. He got some extra parenting time as a result, is what happened.
Oh, so it's not financial related? It's
not financial. So only if you look at when you consider, which the judge did, and it's only if he's clearly erroneous on this. The judge had a 9-day trial. He observed the testimony of the father, the mother. He heard his answers to both attorneys' questions, and he didn't buy it. And he didn't buy it for some very good reasons, which are explained in his judgment, set forth in my brief. And that's what I would say on that issue. One of the cases I raised was that the court does have the jurisdiction to say to somebody, if you didn't get involved in this case, we're going to make you undo the mortgage. The difference is, in that case, there was no signed promissory note. In this case, there was.
But he didn't order the discharge, right? There's some interesting language that he used. He ordered the husband to initiate a process. Which
turned out to not be very...
But I assume if and when the house is sold, the mortgage will be dealt with.
The house can't be sold with the mortgage on it. The father is the named title holder, and my client can't sell it with the mortgage on it, and that's why there's...
Is that because the total mortgage indebtedness then would be more than the value of the house?
No, but there's $850,000 mortgage on the house for the first mortgage. The illegitimate mortgage is up to now about $1.5 million, and so there's some money left over, but not much.
Right, but then wouldn't he be responsible for what you're calling I'll call the promissory note, you're calling the illegitimate mortgage?
Yeah, and the judge called it the illegitimate mortgage as well.
Right. Okay.
So sure he is, but if that's not paid off, who's going to buy a property with a contested $1.5 million mortgage that's been recorded?
Well, you sell it and you put the proceeds in escrow and let the parties fight it out in the probate court.
Then my client doesn't have any money to buy a house for herself and the children.
That doesn't preclude a third-party buyer from purchasing it.
No, it precludes my client from selling it and having the money she needs. As we talked about, there's no bank accounts she received, there's no retirement accounts, there's no anything.
You're saying she's living there now until it's sold, and if somehow a sale were to proceed, she wouldn't get any money and she wouldn't have a way to live.
She wouldn't have enough money to move on with, and that's why the case went back to the judge, and it was after Judge McSweeney retired, Judge Cafazzo issued the second judgment and told him to pay it off within 15 days, if not before, or dissolve it, either one. If he says he owes it, he can pay it as far as she's concerned. But that's a live issue, which I'm probably going to be in the probate and family court tomorrow.
You were asking us to order that the husband be responsible for the payment. It sounds like that issue has already been decided by a different judge of the probate and family court. Is that right?
Well, it hasn't undermined the original judgment, but it added to it. Instead of just initiate the process required to, it's telling him to dissolve or otherwise
right, but you
pay.
were asking for us to do something, and it sounds like you now think we don't need to.
Except that issue is also under appeal now.
Okay.
Right, but not before this panel.
Not in this hearing. It's going to be coming down the road if we don't resolve it somehow otherwise.
Well, I guess what I'm asking is what would our authority to be to do what you asked in your brief in this case?
In this case, I'm just asking to uphold the existing judgment and not do anything other than that.
We will have to leave it there.
Thank you.
Both very well argued, counsel. The matter is under advisement.
In this divorce appeal, judges reviewed disputes over the value of a doctor's medical practice, claims of financial double counting, and an $830,000 family loan tied to a luxury home. The husband argued that the same business income was used both to value the practice and calculate support payments, while the wife defended the trial court's findings. The case centers on asset division, support obligations, and the credibility of key financial evidence. Thanks for watching.